Chapter 23, Part 3. Agencies also can take informal action. They can supply interpretive rules simply declaring policy that do not affect legal rights or obligations. These are just guidance. They're exempt from the APA's regulations because they don't establish legal rights, and a party cannot be directly prosecuted for violating an interpretive regulation. Okay, so we talked about rulemaking. The second thing that agencies do is enforcement. So agencies can conduct investigations to monitor compliance with the rule or terms of an enabling statute. Different agencies have more or less involvement in enforcement. So for example, the Social Security Administration doesn't have a whole lot of enforcement issues. However, OSHA, the Occupational Safety and Health Act, which ensures safe workplaces, has a much bigger role in enforcement and investigation to make sure that workplace safety under the regulations and the statute are adhered to. This often begins with a report that somebody makes to the agency of a violation. For example, a safety issue in a place of work might trigger an agency to investigate. I remember years ago when I was teaching at Athens Tech, there was a pipe at the University of Georgia, a gas pipe, that broke, and that caused OSHA to come down and inspect to make sure that this workplace was safe as a result of that one incident. Okay. So included in enforcement is a lot of times reporting requirements for entities such as employers, and sometimes those can trigger investigations. Also, they're allowed to do inspections and tests, gathering information from work sites, for example, for OSHA. Sometimes inspecting the physical premises is the only way to ensure that there's no regulatory violations. Sometimes it's used in place of a formal hearing in order to show the need to correct or prevent an undesirable condition. So also think about not only OSHA, but think about the EPA. That's an example of where an agency that does a lot of inspections, where there's a indication that there might be something that is affecting the environment and violating the statutes and or the federal regulations. So they cover a wide range of activities, including in safety inspections, safety tests, and environmental monitoring. They can also require businesses or firms to submit records and documents that are necessary to maintain regulatory supervision of that particular business. Usually businesses will voluntarily comply. If they refuse to, the agency has the ability to seek a subpoena or a search warrant. Two types of subpoenas in this situation: a subpoena ad testamentum, or meaning a subpoena to testify. It's an order or a writ by a court compelling a witness to appear at an agency hearing. A subpoena ducis tecum is to bring with the person any books, papers, records, or documents. Now, literally, these two can be combined, where you have a subpoena that requires a person to appear and testify and to bring with them documents, or you could just have a document request through a subpoena ducis tecum. There's limits on the agency's demands. It cannot abuse its discretion and in deciding whether the agency has exceeded its discretion, courts will look at the purpose of the investigation, the relevance of the information that's being sought, the specificity of the demand, excuse me, for the testimony and or documents. The burden is on the person who is on the other end of the subpoena, who the information is demanded from, but the businesses are protected from revealing trade secrets. An agency search warrant is an order directing law enforcement officials to search a specific place for a specific item and seize it for the agency. However, agencies can make searches without a warrant on their own under several circumstances. Highly regulated industries, for example, hazardous chemicals would be one. Emergency situations would be another one. Okay, so that ends part 3 of chapter 23.